Yeah, sit in the chairs that have the black and yellow tape. They have clipboards in the bottom. Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court today for what we call an arraignment. And what the arraignment is basically, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case. Criminal cases are divided into felonies or misdemeanors. Your felony cases are your more serious type offenses, whereas your misdemeanor cases are normally referred to as your petty offense. It does not mean that they're not serious. It just means that they're not as serious as a felony case. And when I use the term serious, what I mean is the facts are serious and the range of punishment, that is the possible punishment that you can get if you're convicted of this case. Now, felonies are divided into 5 categories. You have the capital murder, and we're going to work our way on down. You start at the capital murder, first-degree felony, second-degree felony, third-degree felony, and a state jail felony. Now, if a person is convicted of a state jail felony, the range of punishment is a minimum of 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years, and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life, and a fine that does not exceed $10,000. Now, if a person is convicted of a capital murder, the range of punishment is life in the state penitentiary without the possibility of parole, or death by lethal injection. Now, you do not have to worry about those offenses or those punishments, because your case in this court is a misdemeanor. Misdemeanors are divided into 3 categories, and we will start at the top and work our way on down to the bottom. You have a Class A misdemeanor, a Class B misdemeanor, and then the lowest misdemeanor is a Class C misdemeanor. Now, Class C misdemeanors are those cases that are handled or originate or starts in the JP court, which is Justice Court, or the City Court, which is Municipal Court. Now, if a person is convicted of a Class C misdemeanor, the range of punishment is by fine only. You only can get a fine, and normally it's up to $500. You cannot get any jail time. Now, if you're unable to pay the fine and your fine is converted to community service, or if you fail to pay the fine or you fail to complete community service, then at that point, the court can issue what we call a capias pro fine. A capias pro fine is a warrant for your arrest to sit out the fine in jail. The next misdemeanor is a Class B misdemeanor. A Class B misdemeanor range of punishment, if you're convicted, is minimum 0 days to maximum 180 days in a county jail, a fine from $0 up to $2,000, or you could be given both such fine and confinement. If you're convicted of a first-degree felony, the range of punishment is minimum 0 days in the county jail to a fine all the way on up to 365 days in the county jail, which is a year, or you could be given both, or you could be given a fine from $0 to $4,000, or you could be given both such fine and confinement. As a defendant in a criminal case, you have rights. And the first right we're going to talk about is your right to have an attorney. The paperwork that you have on the clipboard addresses your right to have an attorney. And the first document on the clipboard is titled Judge's Explanation of Rights to Defendants Without Attorney. And it reads as follows. It states that as a defendant in a criminal case, you have 3 options regarding your right to have an attorney. Number 1, you may hire an attorney. Number 2, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Or number 3, you may represent yourself. That is, you may give up your right to have an attorney and represent yourself. Now, if you want an attorney to represent you and you have enough money to hire an attorney, the case will be reset to give you an opportunity to hire an attorney. If you want an attorney, but you do not have enough money to hire an attorney, you would need to fill out a financial questionnaire. The financial questionnaire is the 3rd document on that clipboard. It is titled Jefferson County Affidavit of Indigence. So you would have to fill out that document. You'll fill out the first page and half of the second page. And then the proper person will determine whether or not you qualify to have an attorney appointed to represent you. If you want to represent yourself, that is, if you want to give up your right to have an attorney and represent yourself, then you must first sign a written waiver of your right to have an attorney. Now, the written waiver is the 2nd document on the clipboard. It is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Now, once you read and sign that document, then the court can allow you to represent yourself. Now, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and request that an attorney be appointed to represent you. Now, at the bottom of that document, the first document that I'm going over, it states in bold letters, defendant's choice. Mark your initials next to only one choice. So if your choice is to hire your own attorney, then you will place your initials on the first line to the left. If your choice is, well, if you have already hired an attorney to represent you, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is to request a court-appointed attorney, then you will place your initials on the third line to the left. If you've already been appointed a court-appointed attorney to represent you, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. If you want to waive your right to have an attorney to represent you or give up your right to have an attorney to represent you, Then you will sign your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will sign your name on the line that is titled defendant, and you will date it to today's date, January 16th of 2024. Now, for those individuals who will be waiving their right to an attorney or giving up their right to have an attorney to represent them, as I mentioned earlier, you would have to read and sign the document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. And that's page 2 on the clipboard. And it reads as follows. I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily. Voluntarily means that no one is forcing you to sign this waiver. You're doing it of your own free will. And it says it's intelligently made. Intelligently means that you know what you're doing. Furthermore, I have been advised this 16th day of January of 2024 by the County Court of Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that is your choice, then you will sign your name on the line that is titled defendant, and you will date it today's date, January 16th of 2024. Now, as a defendant in a criminal case, you also have a right to have a trial by jury. In that area over there, we call that the jury box, where those 12 chairs are. 6 citizens from Jefferson County will be selected as jurors in your case. They will listen to all the evidence, they will listen to the arguments, they will deliberate, and then they will decide to find you not guilty or guilty of the charge. You also have a right to waive or give up your right to have a trial by jury. Waiving your right to have a trial by jury simply means that you'll be giving up your right to have a trial by jury. And if you waive your right to have a trial by jury, your case will come before the court or the judge in one of 3 ways. One way it can come before the judge is by way of a trial. It's a trial without a jury. We call that a bench trial. It's a trial by judge only. The judge will listen to all of the evidence and the arguments, and then the judge will decide whether to find you not guilty or guilty. The other way your case will come before the court is by way of an unagreed plea bargain agreement. Unagreed means that, well, first of all, let me do this. A plea bargain is an agreement to settle your case. It's an agreement that you make with the district attorney's office. The gentleman that's sitting at the table is an assistant district attorney. If you're able to work out a plea bargain agreement to settle your case, we call that an agreed plea bargain agreement. If you're unable to work out a plea bargain agreement, we call that an unagreed plea bargain agreement. Now, as I mentioned to you earlier, if you waive your right to have an attorney, if you represent yourself, then you can talk to the prosecutor about your case. Why? Because you are your own attorney. Now, if you have a lawyer that will be representing you, then your lawyer will talk to the prosecutor to see if they can work out a plea bargain agreement. If you or your lawyer is unable to work out a plea bargain agreement, and you still want your case to come before the judge, for the judge to set the punishment, to decide what the punishment will be, we call that an unagreed plea bargain agreement. It will come before the judge, and the judge will set the punishment within the punishment range. In the punishment range for a Class A misdemeanor, Class B misdemeanor, or if your case was appealed from the JP court or the city court, then he'll assess punishment in the Class C punishment range. Now, the third way that your case can come before the court or the judge is by way of an agreed plea bargain agreement. And that is, if you're representing, you say you worked out a plea bargain agreement with the state, or if you have an attorney representing you, your attorney has worked out an agreement with the state to settle your case. It comes before the court. The court can do one or two things. That is, when I say the court, the judge can do one or two things. The judge can accept the plea bargain agreement or reject the plea bargain agreement. Now, rejecting the plea bargain agreement, the judge has said, I'm not going to follow that plea bargain agreement. If the judge rejects your plea bargain agreement, then you have a right to take back or withdraw your plea bargain. So, for example, let's say you and the state has worked out a plea bargain agreement, and the state says, well, judge, we're going to assess 1 day in jail. But they don't have to go to jail because they've already served 1 day in jail. And the judge says, well, I'm not going to follow that plea bargain agreement. Then you can say, well, judge, I want to withdraw or take back my plea bargain agreement since you're not following it. Now, if the judge does follow the plea bargain agreement, and if you decide within 30 days that you would like to appeal your case, you would like to have a higher court than this court to review your case to see whether or not you've been wrongfully convicted or whether or not this court has committed an error by convicting you. Now, if the judge follows the plea bargain agreement, if you want to appeal, then you'll have to get permission from the judge who followed the plea bargain agreement. You have to get permission from that judge to appeal your case. If the judge gives you permission to appeal your case, then your case will go to another court. It will go up to the Ninth Court of Appeals. That's the appeals court. They will review your case to see whether or not you've been wrongfully convicted or to see whether or not this court committed an error by convicting you. Now, the Ninth Court of Appeals, which is located right on the 3rd floor, they can do one or two things. They can either grant or deny your appeal. If they grant your appeal, then they can send the case back down to this court and order this court to give you a whole new trial. Or they could just simply find you not guilty without sending the case here. The other thing that they can do, they can deny your appeal. If they deny your appeal, then you can appeal it to a higher court than the Ninth Court of Appeals. You can appeal your case to the Texas Court of Criminal Appeals, which is the highest criminal court in the state of Texas. You will have to file what is called a pro se petition for discretionary review. Now, pro se means that you'll be filing the petition on your own without the assistance of an attorney. You'll be representing yourself. And you'll be asking the Texas Court of Criminal Appeals to review your case to see, one, whether or not your appeal should have been granted, whether or not this court committed an error by convicting you, or whether or not you were wrongfully convicted. The Texas Court of Criminal Appeals can do one or two things. They can either grant or deny your pro se petition. If they grant your pro se petition, they can simply find you not guilty. Or they can send the case back to the Ninth Court of Appeals, or they can send it back to this court and order this court to give you a whole new trial. Or if they deny your appeal or your petition, your pro se petition, your conviction will stand at that time. All right. Now, you also have a right, besides your right to have a trial by jury, to enter into a plea bargain, an unagreed or agreed plea bargain, or a bench trial. You also have a right to have witnesses to come to court to testify in your case. Now, witnesses, they can either testify for you or against you. You also have a right to waive your right to have witnesses to come to court. That means that you have a right not to have witnesses, your right to call witnesses in your case. Now, just because you will not be calling witnesses, if you waive your right to have witnesses, does not mean that the state of Texas or the district attorney's office will not be calling witnesses, because they will be calling witnesses in the case. You also have a right to have, you have a right, a Fifth Amendment right against self-incrimination. Fifth Amendment right against self-incrimination. What that means, you have a right not to testify in your case. The state of Texas District Attorney's Office government cannot force you to testify in your case. Now, you can waive or give up your right, your Fifth Amendment right against self-incrimination. And by waiving or giving up your Fifth Amendment right against self-incrimination, you will be testifying in your case. You also have a right to have discovery. Discovery means you have a right to see the evidence that the state will be using against you. Or you have a right to discover the evidence, what the evidence is. You have a right to see documents, witness statements, your statements, reports, police reports, lab reports. You have a right to see videos, hear audio recordings. If they have any type of instruments, you have a right to have access to that, to the instruments. So you have a right to have access to the evidence that the state has against you. You also have a right to waive or give up your right to have discovery, which means you have a right to give up your right to have discovery, to see the evidence, or to have access to the evidence that the state will be using against you. Now, everyone that's here today, you have been arrested and you're out of jail. You're out of jail on bond. You're either out on a cash bond, which means that you paid the full amount of the bond to get out of jail, or you're out of jail on a surety bond, which means that you pay a bondsman a percentage of the cash to get out of jail, or you're out of jail on a PR bond or personal recognizance bonds, which means that you did not have to pay any money to get out of jail. You were released under your own personal recognizances. Now, every day that you spent in jail, that jail time can be used as credit toward your punishment. For example, let's say you spent 5 days in jail before you bonded out, and you and the state have reached a plea bargain agreement. And the plea bargain agreement is for you to serve 5 days in jail. Well, you would not have to serve any more time in jail. Why? Because you've already served 5 days in jail. Therefore, you'll be given the credit for the time that you have already served in jail. Now, if they're offering 7 days and you spent 5 days, that means you would only have to do 2 days because you'll have 5 days credit. If the state, now every day that you spent in jail also can be used as credit toward your fine and court costs. Every day that you spent in jail, you will receive credit of $100 that will go toward your fine and court costs. So for example, if you spent 5 days in jail, that's $500 that will go towards your fine and court costs. Now, if you and the state have reached an agreement to settle your case for a fine and court cost of $500, that means you don't have to pay the $500. Why? Because the 5 days that you spent in jail has already paid it off. Therefore, the fine and court costs will be taxed and retired, which means you won't have to pay it. Now, if they're offering fine and court costs of $700 and you spent 5 days in jail, then you would have to pay $200 because you already have $500 credit that's going to be taken away from the 700, so that means you have to pay $200. Now, the $200 would have to be paid on the day that the case is disposed of. However, if you cannot pay the $200 on the day that the case is disposed of, we could put you on what is called a payment plan. That is, you could pay so much each month until the remaining balance of the $200 is paid off. Now, even if we put you on a payment plan, and you might say, well, even if you put me on a payment plan, I still would be unable to pay it because I have no source of income. No problem. Because at that point, if the court finds that you are indigent, meaning that you cannot pay it, then the court can convert your fine and court costs to community service. And that basically means that you would have to work in a nonprofit organization in our community. And for every 1 hour of service that you provide, $12.50 will be credited towards your fine and court costs. So for example, if you're $100, you work 8 hours, that's $100. That will be credited toward your fine and court costs. Now, Jefferson County has a program for first-time offenders. So if you haven't been in trouble before, first time getting in trouble, Jefferson County has a program where they will dismiss your case and they can you can get it wiped off your record. The program is called pretrial diversion. Now, in order to qualify for pretrial diversion, it has to be your first time getting in trouble. It cannot be for an offense involving unlawfully carrying a weapon or resisting arrest. And you have to have an attorney to assist you with the application to get into the program. And as I mentioned, if you get into the program, the case will be dismissed. And if you complete the program, then you can get it expunged. Expunged means erased, deleted, or wiped off of your criminal record. It won't be there. Now, if you're a veteran of any one of the branches of the United States military, if you're a veteran of any one of the branches of the United States military, the district attorney's office has another program that is called Veterans Court. With that program is for veterans only. If you get into the program and complete the program, they'll dismiss the case and you could get what is called a non-disclosure. A non-disclosure means that we cannot disclose to the general public the fact that you are on, that you had this case, or that you were in the veterans program. We can't disclose that to the general public. Notice I said general public. Now the government can have, there are certain government agencies that will be able to have access, but the general public, which is most of the public, cannot have access to that information because you'll have a non-disclosure. Now, this court has a program that is called the CSI program. CSI program stands for Community Safety Initiative. It is a program that started within the first 100 days of taking office. And this program was started in March of 2017. That program is designed to address the issue of what is called recidivism. Recidivism basically means people commit crimes over and over. And so to address the issue of recidivism, I started this program. And this program is designed to make Jefferson County a safer place for all of us to work, go to school, go to church, and raise our families. And the way the program works is as follows. We have a partnership with agencies in our local community. One of the agencies that we have our partnership with is the Spindletop Center. Spindletop Center is our local mental health center. And with the Spindletop Center, what they will do, they will have a private interview. They can do an assessment and develop a treatment plan, either for outpatient or inpatient treatment for individuals who have mental health issues. Now, you do not have to be incompetent or insane to participate in the program. You could merely suffer from anxiety or depression or any other host of mental illnesses. And Spindletop also has a drug and alcohol counseling program, as well as the Golden Triangle. The Drug and Alcohol Council also have a drug and alcohol recovery program. Now, the Spindletop program is known as ATAR. Drug and Alcohol Council program is known as OZAR. Both of those programs are designed where they will be able to do a screening, an assessment, and develop a treatment plan for either outpatient or inpatient treatment to address any issues that you may have with alcohol or drugs. If you're unemployed and do not have a job, or if you're looking for a better job, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, the chemical industry. Once you're trained in any one of those areas that you select, then they will help you or assist you to get a job in the area that you're trained in. If you have not graduated from high school and you would like to get a GED, your graduate equivalency diploma, then CICE also has a GED program. Now, all of these programs that I just mentioned are free, does not cost you anything. Only thing it costs you is time. And in this court, we like to say we don't just give time, we take our time. And that simply means we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people, and we believe that productive people will not commit crimes. And so I like to say that in County Court at Law Number 2, we do not have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And we're trying to make a difference, and we believe that if we make a difference in the lives of the individual that comes before this court, we'll make a difference in their home. And if we make a difference in their home, we will make a difference in the community, because what comes out of the home goes into the community. So if you're interested in any one of these programs, just let us know. We have brochures that have the information and the phone numbers that you can call to participate in the program. Now, the other benefit of the program is this. I mentioned to you earlier when I was talking about fines and how a person, if they could not pay their fine, we can convert it to a payment plan. If you cannot pay the payment plan because there's lack of income, then we can convert it to community service. Now, all these programs that I just mentioned to you can be used as community service. So I tell people this all the time. It's like killing 3 birds with 1 stone. What I mean by that is this. You're in the program, and while you're in the program, you get 1 hour that goes toward community service, and you're getting $12.50 that is going toward your finding court costs. Okay? And so while you say, let's say you were in a job training program, you're in the class for 1 hour. 1 hour is going toward community service, and $12.50 is going toward your finding court costs. So you're being trained for a job, and while you're being trained for a job, you're also paying your community service. I mean, you're paying your finding court costs, and you're performing your community service just by doing one thing. And that's the same thing if you're in the drug program, or if you're in the mental health program, or if you're in the GED program, it's the same thing. Okay? So if you're interested in those programs, as I mentioned earlier, we have brochures. Now, normally, we usually have individuals from Spindletop, as well as the veterans administration who's in here in court to talk to you about the programs that they have to offer. Now, I can say this. Now, I briefly mentioned to you the programs that Spindletop has. Spindletop has more programs that they can offer, and it's all on the brochure. The Veterans Court, they have more programs and services that they can provide to you, and that is also on the brochures that we have. Now, if you're interested, just let us know, and we'll be happy to get you that information. Now, the next thing is this, or the final thing is this here. You've been handed out clipboards. You need to make sure that the clipboards are filled out. If you need any assistance to fill out the clipboard, we have our court personnel who's here who will be happy to help you, assist you. Now, once you fill out the clipboard, we're going to pick up the clipboard from you. And then we're going to go through the information to make sure everything is filled out properly. Once we finish making sure everything is filled out properly, we're going to call you up before the bench or before the court, one at a time. And you're going to stand before me, and then we're going to put you in one of three categories. One category is you want to hire. Another category, maybe you want to see if you qualify for a court-appointed attorney. Or the other category is, well, you want to represent yourself. And so we're going to call you up one at a time, and we're going to go through that. And once we finish here, you'll be free to go. Now, this, as I mentioned earlier, it's going to take us a little time to get that information from you. But if you need to use the restroom, there are some restrooms that's right outside in the hallway. The men's restroom is right next door in front of County Court at Law Number 3. The women's restroom is on the opposite side of the hall in front of the 172nd District Court. Now, the court is going to allow you to go out in the hallways, use the restrooms, and when you finish, you can come back in. Now, do not leave the courthouse because you're here today and you've already checked in, but if you leave without finishing what we need to do here in court, a warrant can be issued for your arrest because your bond can be forfeited. Okay, so this is not going to take us too long. We're going to try to get you out of here as fast as possible. First of all, I'd like to thank each and every one of you for coming here this morning. Hopefully and prayerfully, everyone made it safe. We did not have any accidents or anything on the roads or anything like that. But be mindful that when you leave here, you still need to be safe. You still need to drive safely, okay? Because it's not over, all right? But again, we're going to try to move as quickly as we can. Now, if anyone need any help, just raise your hand. Anybody need some help? Okay, we got some, and we have our court personnel who's here, who's happy to help you. Okay, so the court will be in recess. Jefferson County Court at Law number 2 is back in session. The court is in session with the arraignment docket. First case is cause number 23CCCR 2348. Case is style the state of Texas versus Cohen Keith Salyer. Salyer, would you please come forward? You're gonna stand in front of the bench. Now, your full name is Cohen Keith Salyer? Do you pronounce Salyer or Salyer? Salyer, okay, Louisiana. All right. Now, Mr. Salyer, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. How are you doing, Mr. Salyer? I'm doing fine, thanks for asking. Mr. Salyer, I have before me two dockets. The first docket, two documents. The first document that I have is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature online as titled defendant? Are these your initials online that states you'd like to waive your right to an attorney and represent yourself? I also have another document here that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. Do you recognize this document? And is this your signature on the line that is titled defendant? Now, Mr. Salyer, before you signed and initialed all of these documents that I just showed you, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Salyer, you stated that you want to waive your right to an attorney and represent yourself. So one of the prosecutors is going to come and talk to you. Just go back and have a seat. You're welcome. I'm going to set this right here. Next case is cause number 23CCCR 2378. Case is styled the state of Texas versus Dale James Dennis. Mr. Dennis, your full name is Dale James Dennis?
Yes, Your Honor.
How you doing, Mr. Dennis? Okay, Mr. Dennis, would you please raise your right hand? Mr. Dennis, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Dennis, I also have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant? And are these your initials on the line that is titled, that states rather, you would like to have your case reset to hire your own attorney? Now, Mr. Dennis, before you signed and initialed this document, did you read the documents?
Yes.
Did you understand what you read? And is everything in this document true and correct to the best of your knowledge?
Yes.
Okay, Mr. Dennis, just have a seat. Your case is going to be reset by our court coordinator. Have a seat in that first chair. Once your case is reset, you'll be free to go and you have a blessed day. Pass that to her. Samuel Lopez. Mr. Lopez, would you please raise your right hand? Mr. Lopez, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. How are you doing, Mr. Lopez?
Doing good.
You doing good? That's it. Now, Mr. Lopez, I have two documents before me. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled defendant? Or are these your initials on the line stating you'd like to apply, or that you would like to waive your right to an attorney and represent yourself? I also have another document here that is titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceeding to Trial. You recognize this document? And is this your signature on the line that's titled defendant? Now, Mr. Lopez, before you sign and initial these documents, did you read the documents? Yes, speak up.
Yes, sir.
And did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Lopez, I read your answers. You can have a seat and the prosecutor is going to come out and talk to you.
Samuel Lopez, Your Honor?
Yes, Samuel Lopez. Court is in session in cause number 23 CCCR 2224. Case is style of State of Texas versus Paulette Guillory. Ms. Guillory, would you please come forward? I know. Ms. Guillory, your full name is Paulette Marie Guillory?
Yeah.
Ms. Guillory, would you please raise your right hand? Ms. Guillory, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
Ms. Guillory, you may put your hand down. How are you doing, Ms. Guillory?
All right.
That's good, Ms. Guillory. I have before me some documents. The first document that I have is, actually, it's two documents. The first document that I have is titled, Judging Explanation of Rights to Defendants Without an Attorney. Do you recognize this document?
Yeah.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line stating you'd like to apply for court-appointed attorney?
Yeah.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yeah.
On page 2 of this same document, Ms. Guillory, there is a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, it is.
Ms. Guillory, before you signed and initialed these documents that I just showed you, did you read the documents? And did you understand what you read?
Yeah.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Guillory, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Peter Doyle. Attorney Doyle will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information, but before she gives you that information, I need to have the bailiff give you some bond conditions. And I'm going to go over these bond conditions with you. Ms. Guillory, the document that has just been handed to you is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that title?
Right here.
Yes.
Yeah.
Okay, I'm going to go over these bond conditions with you, and it reads as follows. Following the return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yeah.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who, A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yeah.
And condition number 3 states, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense. And the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yeah.
Now, condition number 4 does not apply. However, condition number 5 does apply. And condition number 5 on the second page states as follows: defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 Penal Code, actively engaged in employment as a sworn, full-time, paid employee of a state agency or political subdivision. Do you understand that condition?
Yeah.
Now, Ms. Guillory, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You can have a seat in that first chair by the wall, and when the court coordinator is ready, she's going to call you to the window. And once she finishes her window, you're free to go and you have a blessed day.
Okay.
Seat in that first chair on the wall. Next case is cause number 23CCCR 2356. Case is styled the state of Texas versus Caden Dean Sharon. Mr. Sharon, your full name is Caden Dean Sharon. Mr. Sharon, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Sharon, you may put your hand down. How are you doing, Mr. Sharon? That's good, Mr. Sharon. I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And is this your signature on the line that's titled Defendant? And are these your initials on the line that state you would like to apply for court-appointed attorney? And I also have before me a document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of this same document, there is a signature above the line that's titled Defendant Signature. Is that your signature? Now, Mr. Sharon, before you sign and initial these documents, did you read the documents?
Yes, sir.
You understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge? Now, did I swear you in?
Yes.
Okay. Now, Mr. Sharon, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. The attorney that would be appointed to represent you in this case is Attorney Mark Faggett. Attorney Faggett will be given information to contact you. You will be given information to contact him. Our court coordinator is going to give you that information. Once she gives you that information, you'll be free to go and you'll have a blessed day. Please have a seat in that third chair on the wall. Welcome. Aisha Hinton. Ms. Hinton, your full name is Aisha Hinton. Ms. Hinton, would you please raise your right hand? Ms. Hinton, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Hinton, you may put your hand down. How are you doing, Ms. Hinton?
Okay.
That's good, Ms. Hinton. I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant? Are these your initials on the line stating you would like to apply for a court-appointed attorney? Ms. Hinton, I also have a document that's titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of this same document, there is a signature above the line that is titled Defendant Signature. Is this your signature? Ms. Hinton, before you sign and initial these documents that I just showed you, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Ms. Hinton, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney David Grove. Attorney Grove will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once you get the information from the court coordinator, you'll be free to go, and you have a blessed day. Please have a seat in that third chair. Lonnie Artrell Dockery. On the bottom. Mr. Dockery, your full name is Lonnie Artrell Dockery? Okay. Now, Mr. Dockery, your full name is Lonnie Artrell Dockery? Okay, Mr. Dockery, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Dockery, you may put your hand down. How you doing, Mr. Dockery? That's good. Now, Mr. Dockery, oh, I'm doing fine. Mr. Dockery, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And is this your, or is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials online stated like apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled, that was kind of affidavit of indigence. Do you recognize this document? On page 2 of this same document, there is a signature above the line that is titled defendant signature. Is this your signature? Now, Mr. Doctor, before you sign and initial these documents, did you read the documents? Did you understand what you read?
So much,
What?
so much.
You say, okay, what did not you
A
understand?
little bit about the income situation. That was it.
The income.
That's, she,
Somebody help you?
yes, yeah.
Okay, that's good. Now, is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Dockery, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in this case is Attorney Benjamin Jeffries. Attorney Jeffries will be given information to contact you, and you will be given information to contact him. Our court coordinator is going to give you that information. Once you get that information from the court coordinator, you'll be free to go. But before the court coordinator gives you that information, the bond, our bailiff, the bailiff is going to hand you some bond conditions. I'm going to go over these bond conditions with you.
Yeah, there was two charges that was together. This charge right here, that I have right here, it was, evaded. And it was a evaded charge that's supposed to go on this charge, Brittany Holmes with the lawyer, You're supposed to have both of them.
Oh, well, she's the lawyer. I got a conflict of interest. She said,
She's supposed to have.
he said that,
Two charges together.
she's represented by Brittany on these cases. But y'all look. Who's gonna look it up? His name is Lonnie Dockery.
She's supposed to be an attorney for both cases.
Okay, he say he has two cases.
One of them just been dismissed,
Oh.
evaded.
Huh? He says, what cases? You said you had two
They
cases?
had two, guys had evading and, unlawful carry with a
You
file.
said it's evading and unlock, and look for the evading.
Evading has already been disposed of.
Okay,
November 29th.
okay, so what we're gonna do is, we're gonna have to transfer this. Okay. There's a conflict of interest.
I understand.
Okay, and so the case is gonna have to be transferred to the court next door. They're not in session today. And so let's, yeah, his name is Doctor. Right.
So he should be receiving something from their court, but stay in contact with your bondsman.
I
Right.
have a bond.
You pay the cash bond,
They gave me
PR bond?
PR bond.
So you'll be sent notice of your reset date, right?
Like, we're still.
But I'm on the road. I'm on the road tomorrow.
No, I mean, you ain't gonna, I mean, but whatever your address is that you have, that's the address that your bond is gonna, that information is gonna be sent to. Unless you change the addresses.
Okay.
Okay, yeah, so that case is gonna be reset. I got a conflict of interest, so I can't go forward on this one. Okay. So is he free to go? Hold on a minute. Yeah, I don't need that. I mean, Yeah. Take this here off.
Okay. So,
Who?
oh, he got this. Okay, how did you get how did you get noticed the last time?
But you can send to the address and my kid's mother, son mother,
No, I'm asking, how did you know it was actually today?
today. She called me on the phone.
Okay, so you got a notice. Hold on a minute. Hold on a minute. What interest?
Like if his address is different from the time.
He said it's the same.
Oh,
Yeah.
okay. No, but what I'm saying, let's say there was.
Well, I already asked him that.
I lost the house, but
Yeah.
she goes out.
I don't know what we did. That's not important right now. Yeah, okay, so, you can go ahead on and leave. Your, case is being transferred next door, and you're gonna get notice in the mail. All right, we'll see you later. You have a blessed day.
Do you need that guy to come over?
Oh, who's the guy that had the warrant? Okay, they already got him? All right, here you go. That's gonna be shredded.
No, some of that Duncan got it.
Okay, next person.
I just sent you.
Okay, I'm gonna get this. Alan Marquez. Your name Alan Martinez Marquez?
Yes.
Mr. Marquez. Mr. Marquez, do you speak English? Okay, a little, okay, let's do this here.
Or one part because of that one we have.
Yeah, well, he can come, but I mean, at this, I see where he has, said he wanted to waive his right. I mean, I don't know, but we're gonna have to, reset his case anyway. Okay? No, we have somebody. Yeah, go ahead on and get, Oh, that door is locked. Yeah, okay. It's the charge up. Yep. Oh, I need to give him some bond conditions to sign you before we leave. You can give me his paperwork back. Okay. Jefferson County Court at law number 2 is back in session. The court is in session in cause number 23 CCCR 0232. Case is filed in the state of Texas versus Samuel Lopez. Mr. Lopez, is that your full name? How are you doing, Mr. Lopez? That's good. And Mr. Lopez, would you please raise your right hand? Mr. Lopez, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God? Mr. Lopez, you may put your hand down. Mr. Lopez, I have before me a document that is titled information sheet. This information sheet was filed by the Jefferson County District Attorney's Office. In this information sheet, it alleges that you, Samuel Lopez, on or about January 19th of 2023, while you were in Jefferson County, Texas, that you committed Class A misdemeanor offense of theft. Mr. Lopez, do you understand what you have been charged with?
Yes, sir.
To this charge, how do you plead guilty, not guilty, or no contest?
Guilty?
Are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes, sir.
Mr. Lopez, I also have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. And do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to waive your right to an attorney and represent yourself?
Yes, sir.
I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Mr. Lopez, I also have a document that is titled Misdemeanor Plea Admonishments. Also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a set of initials. There are 2 sets of initials. First set of initials is below a paragraph that is titled waiver, and it's on a line next to a box that says guilty. Did you place your initials on this
Yes,
document?
sir.
Second set of initials is before a paragraph that is titled discovery certification. And the initials are on a line, actually it's below a paragraph that's titled discovery and admonishment. And the initials are on a line next to a box that states, I do not request discovery of evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest. Did you place your initials on this document?
Yes, sir.
On page 3 of this same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
I also have another document that is titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
We're gonna have to put him back on the arraignment. Yeah. And Mr. Lopez, before you signed and initialed these documents, did you read the documents?
Some of them, sir. Yes, sir.
You said some of them.
No, yes, yes, I did.
You read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Lopez, are you a citizen of the United States?
Yes, sir. Yes.
State, I have before me State's Exhibit number 1. State, would you like to offer State's Exhibit number 1 into evidence?
Yes, Your Honor.
Now, Mr. Lopez, the state is offering State's Exhibit 1 into evidence. State's Exhibit 1 is the document that has on page 1, the box that's checked that states that this is a Class A misdemeanor. And on page 2, it have your initials in these 2 locations. Page 3 has your signature. Now, the state would like to use this document as evidence in your case. Is it all right for the state to use this document as evidence in your case? Okay. Now, I failed to mention, Mr. Lopez, you have a right to have a record made of this proceeding. And what I mean by record, you have a right to have a court reporter to type everything that's being said. You also have a right to waive or give up your right to have a court reporter to type or to record these proceedings. Do you waive or give up your right?
Like record what we're doing right now?
Yes.
You can have it.
You want a court reporter? Okay, so let's see if there's a court reporter available. Just have a seat.
Do it necessarily need to have it?
That's your choice. So, I mean, you have a right to. You can waive it or you can have it.
What would be more easier?
I can't give you any legal advice.
I'll just wait.
You waive it? Okay, that's fine. Now, Mr. Lopez, is there any evidence that you're currently mentally incompetent to stand trial? You have any mental problems that affect your ability to understand
No, sir.
what's going on and the consequences of you entering into this plea? You understand everything?
Sure.
You know what you're doing? Okay. Now, Mr. Lopez, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement in this case?
Yes, Your Honor.
And what is that agreement?
The agreement for a plea of guilty is 1 year deferred probation with the fine waived, 40 hours community service.
40 hours of community service?
Yes, Your Honor.
Okay.
Restitution of $2,364.15.
$2,364 and what?
15 cents
15 cents to,
to Academy.
okay, that's the Academy store.
Yes, Your Honor.
Okay,
And the requirement the defendant take a theft class.
F class. What is his court cost?
277.
277. It's 1 year. Plus the restitution. $2,364.15. Okay. Mr. Lopez, the state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you will not be required to pay a fine. The state is waiving the fine in this case. However, you will be required to pay court costs of $277. You'll be required to pay restitution in the amount of $2,364.15 to the Academy store. You'll be required to pay a probation fee of $60 a month, a year analysis fee of $15 a month, and you will be required to pay a restitution fee of $15. Your total monthly installments, that is the total amount that you will be required to pay each month while you are on probation, is $323.28 a month. Well, it'd be $323 a month. Will you be able to pay the $323 each month?
I think so.
Okay. You will also be required to perform 40 hours of community service. You will have to attend and complete a deaf class, and you will be required to adhere to the other standard terms and conditions of this probation. Mr. Lopez, do you understand the state's offer? Do you think that the state's offer in your case is fair and just? And do you accept the state's offer? Mr. Lopez, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Lopez, if you successfully complete this probation, this case will be dismissed. It would not result in a conviction on your record, and you may qualify for a non-disclosure. You can talk to an attorney about the non-disclosure. Now, Mr. Lopez, you're going to have a seat in that first chair on the wall, and when the court coordinator and the bailiff is ready, they're going to call you, and once you finish, you're free to go and you have a blessed day. That's Lopez. Coinsaya. Hayden, Coin. Okay, that's Coin Keith Sawyer. Mr. Sawyer, let's see, previously we had you. Okay, now Mr. Sawyer. Would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Now, Mr. Sawyer, again, I have before me judge's explanation of rights of defense without attorney recognize this document. And is this your signature online inside the defendant? The bottom of this document, there's a set of initials on the line that state you'd like to waive your right to an attorney to represent yourself. Is that correct? I also have another document that's titled waiver of counsel for purposes of entering a guilty plea or proceeding to trial. Do you recognize this document? And is this your signature online inside the defendant? Now, before you sign and initial these documents, did you read the documents? You understand what you read? And is everything in these documents true and correct to the best of your knowledge? Now, Mr. Sawyer, as I mentioned to you earlier, the state said there's another case that has not been filed. And so we're going to reset this case to give the state an opportunity to file that case so we can dispose of these two cases at the same time. Now, before our court coordinator give you your reset, I need a bailiff to give you a copy of these bond conditions. I'm going to go over these bond conditions with you. Mr. Sawyer, the title of the document that you have in your hand is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that title?
Yes.
And it reads as follows. Following the return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition?
Yes, sir.
And condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court may revoke the bond and order arrest of any defendant who, A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
Now, condition number 3 and 4 does not apply. However, condition number 5 does apply. And condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn, full-time, paid employee of a state agency or political subdivision. Do you understand that condition?
Yes.
Now, Mr. Sawyer, if you violate any one of these conditions, your bond may be revoked, and if your bond is revoked, a warrant will be issued for your arrest, and you'll be placed in Jefferson County Jail. Do you understand that? Mr. Sawyer, your case is going to be reset. Once your case is reset, you'll be free to go and you have a blessed day. Please have a seat in that third chair on the wall.
Yes. I guess we're like holding the lines.
Okay, hold on a minute. Right. Okay, Paul. Okay, Michael Duncan is going to be dismissed. Is that correct?
Correct.
Oh, before you do that, did it? Oh, Lopez, here it is right here. I need to put the date in. Never mind. Hold on a minute. Whatever. January. Let me make sure everything is set. Oh, I didn't sign this.
I think Sawyer.
So that's 16. Ma'am, thank you for interpreting.
Sir?
Thank you for interpreting earlier. Okay.
And today we'll allow it.
Okay. We'll conclude the calling of the court's arraignment docket on today's date. of January 16th of 2024 in County Court Law Number 2, Jefferson County, Texas. Everyone, please have a blessed day. Make sure that if you're driving, make sure that you drive safely and stay warm.